This is We the People News. Not an attorney, not giving legal advice. Educational purposes only. Alright? And just come on, people. Think outside the box. Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. Alright? Arm yourself with knowledge. Use that Second Amendment. So, this is Speedy Trial Act of 1974. Okay? We all heard about speedy trials. And I'm going to do a little bit of deep dive. All this administrative process is supposed to make everything go smoothly and more easily. However, don't it seem to take a good couple of years about fighting this, all these things, from beginning to end? So, overall, how is it making it easier? Your attorney's got to put lots of motions in, and then, the prosecutor's got to put motions in, and all these kind of paperwork is going in and out there. When this can be done in said time frame. That being said, there's a catch-22, right? Within the time frame, there's going to be mistakes done because they're going to be quickly doing things. So just to give you notice.
Not really sure whose accent that is, so just gonna offend everybody equally, because that's what we do as Americans. All right, so let's share the screen and see what we can find. All right. So let's take a look, I guess, at Cornell Law. See how they like to watch me? Well, I like to watch them too. So let's take a look. All right. Let's see here.
Primary tabs. Speedy Trial Act. The Speedy Trial Act of 1974, codified at 18 U.S.C. Section 3161.
Codified, turned into code, made into law. That's what that means. So let's go.
ETC is a United States federal law that establishes time limits for completing various stages of a federal criminal prosecution. Its main purpose is to ensure that defendants are not held indefinitely without trial and to prevent undue delay in the administration of justice. Under the Act, a criminal defendant must be brought to trial within 70 days of either their indictment or initial appearance in court. And
did you hear that? Some of y'all don't know that right now, because they've gone over 70 days since the moment of the occurrence. Listen to what I'm saying. Gem drops for those people who have ear to hear, eyes to see, and the brain to know. Never forget the old adage, you have two ears and one mouth. You should be listening twice as much as you speak.
That being said, here in Texas, it's kind of fairly standard that they decide to dismiss it right at the 2-year mark. And the reason why they do it right at the 2-year mark, I'm led to believe and do believe, is due to the hairiness of the lawsuit against the officers or whoever may be in this order, right? So they stretch it out at minimum 2 years. But that being said, how fast could the judicial branch be rolling along if they actually went by this standard, people?
You are not to be held indefinitely without trial. They have 70 days from the initial indictment or initial appearance in court to conclude this matter.
Roughly 2.5 months.
Or they're in violation of your due process. You can privately communicate this. You can play this how you want. How would I play it? If we are in violation, or should I say they are in violation, I would motion to dismiss, and I would say, Your Honor, we're 75 days, 71 days, 72 days, 73 days, whatever it is, past my initial appearance or indictment, and you brought these things against me. I motion to dismiss for failure of due process according to the Speedy Trial Act of 1974. We've exceeded the 70 days, but let's see what else they have to say real quick, like.
Unless certain delays are automatically excluded from this 70-day period. The Act also...
So what this could mean here, automatically excluded, so certain delays causing it to go past here, like let's say maybe COVID or, COVID as in COVID. All right. Or some.
And I'm led to believe that's going to be more along the lines of some type of emergency. Okay. Hurricane came through and the courts were shut down. Some form of emergency.
Like, an alien invasion or whatever, educationally speaking, entertainment purposes. Those are all information, programs, files, and things said here. Yeah. So with that being the case, if they're out past that, I'm going to say, motion to dismiss, but let's keep going. See what else they say.
Also outlines procedures for granting continuances and extensions of time limits.
So they have to file. So if they are past that time, they can file for a continuance or an extension.
As well as the consequences for violating its provisions.
But if violated, this will be a motion, a reason to dismiss.
So technically, they're not still supposed to be getting off scot-free. Not attorney, not giving legal advice. So once they go past due, then they decide to do this right here, as well as the consequences. So if they decide to file continuance and all that, well, that prosecutor is supposed to be in trouble. Just saying. There's a consequence for, extending it. Well, because we're not supposed to be just sitting there. We want to get this stuff done, so proceed forward in our lives without being hindered.
All right. So, let's see here. There it is. Close that. Let's see here if they have anything additional. They talk about court cases. We don't need all that. You guys get the idea of it.
When you pull that up, look up the court cases it speaks of, and especially anything that has to do with continuance, and find out what the process. And look up on the criminal criminal rules of procedure and find out what it says in your particular state. But this is supposed to be for state and federal government. 70 hours, people. You spend more than that in jail most of the time.
Okay, so let's go up.
That's the reason why your bond's not supposed to be excessive, so you can get out and actually deal with the matter. And since you can't do it in jail, if I make $10,000 a month, and they telling me it's $1,000 to bond out or $100,000 bond out, that's excessive. If I'm a millionaire, well, that's not excessive.
To
Which goes by in the common law. Each and every case is different because it's my case has nothing to do with another case 20 years ago.
all right, so in one of the particular cases, the case had gone 7 months, and so they issued in a motion to dismiss the matter pursuant to the fact that it shouldn't have been no more than 70 days of doing all of this. The case, okay? No more than 70 days shall elapse, and then it is the prosecutor's duty to dismiss the charges. In any case in which a plea of not guilty is entered, the trial of a defendant charged in an information or indictment with the commission of an offense shall commence within 70 days from the filing date and making public. Okay? A lot of times they're supposed to make these things public, and they're really not. They're keeping it on their private side, which is why you want to make sure it's on the record. Meaning real, law, visible, recorded, not just in-house. Okay, that the defendant has appeared before a judicial officer.
Now, he's not going to go in deep in this part, but in the judicial officer, to appear in a judicial officer, not a magistrate. And this is where we've been kind of staying in. We've been staying in a magistrate section. And that's the reason why you hear some of these people talk about, well, the Constitution does not apply in this courtroom. Well, it's because it's not a judicial branch. It's administrative. And even with your criminal charges, they are still putting that in administrative. You very rarely, you have to call it out. You have to say, I want to see a judicial judge, not a magistrate, administrative. We all getting charged and sentenced technically by a magistrate. And when you go on Microsoft, they don't even recognize what magistrate is because it's not really real. All right? We're not supposed to actually have to go and see a magistrate overall. All right? We do it, but that's not the way it's supposed to work. Originally intent.
Of the court in which such charge is pending, whichever date last occurs. If a defendant consents in writing to be tried before a magistrate on a complaint, the trial shall commence within 70 days from the date of such consent. The remedy for a violation of a defendant's Sixth Amendment speedy trial right is a dismissal of the charges with prejudice. You guys have heard me say that before, right?
All right. I went over that too, without prejudice, with prejudice. They cannot bring it back up with prejudice. You always want to make sure it's on the record that's with prejudice, not without prejudice. Okay? So they don't come back 20 years later and arrest you because there's another warrant. These are We the People News. Until next time. Bye, y'all.